We're on the record. In the case of Wealthy Silva versus Rogerio Silva, 467820. Your appearances, please.
Good afternoon, Your Honor. Robert Weatherford, bar number 7949, here with the plaintiff, Wealthy Silva.
Thank you.
Good morning, Your Honor. Or good afternoon, Your Honor. Leslie Cohen, bar number 6605, with the defendant who's also present.
Thank you. This is the time set for order to show cause hearing. Mr. Weatherford, you didn't indicate that you were unbundled, so are you retained?
I am unbundled. I apologize, Judge.
Okay.
Thank you for
right.
catching that.
Thank you. The order to show cause was issued by the court and electronically filed on June 14th, 2016. I received plaintiff's objection yesterday that was electronically filed, and I'm going to address her points because she has made some valid points in her objection. I issued an order to show cause for failure to obey the court's orders of May 12, 2016. And when I issued this in June, the order had not been submitted but was pending. It has been rejected by the clerk of the court, I believe a couple of times, so it remains incomplete. Therefore, we cannot proceed on a motion, on an order to show cause. It's not a motion, it's an order to show cause on the May 12, 2016 order because it's not complete.
If I may address that, Your Honor, you have issued, you filed an order in an open court in order for supervised exchange. That didn't go forward because of the plaintiff's actions. So we can go forward under that order. That definitely was filed.
Talking about the referral to Donna's house for supervised exchanges.
Yes, as far as
Unfortunately,
the
I'm not on
order.
notice of any
Hold on,
of
sir,
that
let
today.
her finish. That was proceed. Go ahead.
Yeah, and as far as the order, I wasn't aware that it was rejected twice. I submitted it. I wasn't aware that it was rejected the first time until I called the department and said, where's the order, what's going on, and was advised it had been rejected. I submitted it a second time and actually called the department this week to say what's going on, where's my order, and was told what order, we haven't received it. I had emailed it and had sent it with a runner, and so when I was told that it wasn't received, I was a bit surprised, so I resent it. So as far as I know, it wasn't rejected a second time, but I do understand the rules are rules as far as an order, and that's why I suggest we move forward based on the order for supervised exchange.
Okay. Your order was logged in on June 29th, forwarded to the court clerk for review. It was logged out on July 11th, rejected by the court clerk, not this court clerk, but someone else who was sitting in. So it was logged out on July 11th. We received it again on I don't know when we received it again, but again it was logged out. We received it again on July 26th, forwarded to the court clerk.
Right, and as I said, that was actually the third time I had sent it because
Carol Critchett, I believe. Did you say it was Carol Critchett? Carol Critchett was the court clerk that sat in that day. She's in control of that order. So if she's rejected it, it never made it to my desk. It only made it to her. So she's the person you need to communicate with as far as whether or not she's approving it, because she was the record keeper for that day.
Right, and additionally, Your Honor, however, as I read your order for the order to show cause, we're dealing with the testing, the HELOC, and the visitation, all going back to the time of the decree being entered. We've got numerous orders.
I'm just addressing them one at a time.
Okay.
All right?
Judge, if I may address that quickly. State DCFS, First District Court, obviously you know this, the order has to be written, signed, and filed in order to hold my client in contempt. Further, if there's going to be any contemptuous actions, it has to happen in front of this court if there's no written order. And here, there's no May 12th order, and any of the unsupervised business did not happen in front of this court.
All right. The next issue. Why she should not be held in contempt for violations of the decree of divorce for not refinancing the marital residence or in the alternative having it sold. Now, because we have had so much going on in this case regarding, you can have a seat, reunification and supervised visits, visits not happening, full child custody evaluation being ordered. It goes on and on and on. The HELOC, unfortunately, got lost in the mix. The decree did order her to pay the HELOC, and we had a hearing on that in February of 2015, so well over a year ago. And at that time, I ordered her to pay the HELOC or list the residents for sale. I ordered that the child be math tested by Clark County School District or another facility of father's choice, and father to pay the cost. We were back here in May, on May 26th. I again ordered her to continue paying the HELOC, but if it was more than 60 days late, the house would be listed for sale immediately. She was to provide proof of HELOC payments and the current balance. I did see in the paperwork not just her recent filing as of yesterday, but other filing where that information was produced. It was in her HELOC brief as of September 10th, 2015, that she was paying the HELOC. We were here August 25th. At that time, I ordered the parties to prepare HELOC briefs. And then November 4th, I issued an order to show cause why she hadn't completed the math testing. And that was specifically, you had given Mr. Tillman a letter as of July 27, 2015, saying that father chose Sylvan Learning Center for her to be tested at, and that he was paying for it, and the letter was ignored. And that's when we were in court on the 4th of November, and I entered an order to show cause why she shouldn't be held in contempt for not having tested with Sylvan Learning Center as you suggested. That's what your request was. The HELOC was still an issue because I had the briefs. Unfortunately, you served Lynn Schoen and not Lynn Conant, I believe, your HELOC brief. So we had a service issue of the HELOC, or maybe it was prior counsel, Brianna Durrett. So we were back here in December 8th, I ordered reunification and another status check. And January 25th, 2016, again, the order to show cause from November the 4th was discussed, and a hearing set on March 1st, 2016. I also ordered that the HELOC would be addressed at the evidentiary hearing because I had scheduled an evidentiary hearing on March 29th, 2016, which I later vacated. So that's what happened to the HELOC issue. It was briefed. It was ordered to be subject of an evidentiary hearing on March 29th. But when visitation was not happening, I saw that as the main issue, and I vacated the hearing and instead issued a minute order for a full outsourced custody evaluation with psychological evaluation of the parties to take place. Because what I saw happening, I thought there were underlying psychological issues. And that did not happen because plaintiff did not have funds. So again, I ordered visitation for father, unsupervised, but the visitations were to take place as far as the exchanges at Donna's house. Now, I received a report from Donna's house that the child didn't want to go. And then the second time, father didn't show because, I assume, the child didn't want to go the last time he was there.
Actually, Your Honor, our office was notified by Donna's house that they were not doing a second visit. We had already filed for the OST, but we, as far as the time frame, I just got this Donna's house report, so that was, I would have contacted them if I had known.
I thought it was a little confusing what she wrote. because even in the addendum, she has the date wrong. She says May 4th, and it was obviously May 14th. So,
Yeah, our understanding was that they had already closed it. That's why he stopped going, and we had filed our OST, or request for OST. You had not granted the OST at that point. So, and in fact, I don't think you actually did. You did your minute order sua sponte, but that's why he didn't appear. Of course, he would have appeared if he had understood that Donna's house was still expecting to see the parties.
I know there was probably some miscommunication with Donna's house. It's not unusual. Unfortunately, it looks like something happened where they closed out the case. I didn't authorize that it be closed out. And I do have questions of the Donna's house staff on why they closed this out, whether or not he was advised that there was another scheduled visit. Because they said, per their policy, 2 consecutive no-call, no-shows, less than 24-hour cancellation, refusal from the child at issue, which they reported happened, and or cancellations due to lack of financial resources may result in case closure, and they closed the case. So I don't have a definitive answer as to whether or not it was plaintiff that caused it to be closed. So I still have a question of fact on that. As I said, the HELOC issue was clearly still an issue. Yes, I entered an order that she was not to be more than 60 days late on a payment, or it would be immediately listed for sale. And there was argument going back and forth on whether it was equitable for her to pay it or not pay it. He didn't want it on his credit any longer. She was making the payments, and I said, you need to brief that, and I will hear it at trial. That's still what I'm going to do, because she has made the payments.
I'm sorry, Your Honor, but she hasn't. She's making interest only. She's not making the payments.
What are the payments?
What's the adequate payment would be like $700 in a matter of like 20 years. That'll
Right.
give,
Well, it's going to take 100 years to pay it at the rate she's paying it.
not gonna pay it. Nothing, like no payments being done towards the HELOC. Only interest.
Okay, I'm going to hear that at trial. That's going to be a trial issue, as well as permanent custody, your modification, your request for modification of child custody, and related to that is child support. What I'm finding today is the only appropriate issue to proceed on, the order to show cause, is whether or not she had the child math tested, as I ordered, by someone of your choosing, and for you to pay.
May I address that briefly?
I saw her paper, and
I have a different argument, Judge.
okay, all right. The June 25th, 2015 paper was discussed in court a couple of times. It didn't comply with my order.
Well, obviously I'm just catching up to speed, and reading all these documents, it's kind of like this thing snowballed. At first, your court order was, minors shall be tested through CCSD or another facility of defendant's choice. It has since snowballed to a facility of defendant's choice for whatever testing, and it's all these different requirements. She complied with the original order. The CCSD, yes, she took the child to CCSD and had her tested, and she tested at the 5th grade level.
It was someone of his choosing. I said it can be CCSD, it can be someone else, and as of July 27th, when we were in court, there was a letter that counsel presented that said this is what he's choosing, for her to be tested at Sylvan.
Right, and I'm going to read you what your clerk wrote. Again,
That's not the official court.
I'm sorry.
And we can go through the orders.
It's not the official record, but you
And
don't
it
need
says-
you don't need to read it to me, 'cause
right, it says or. It says CCSD, or.
of his choosing.
Right, and if the court order didn't comply with this, then it would be rejected by your court clerk, because this is the unofficial transcript of the hearing.
Okay, you can't spin it now, Mr. Weatherford. We've already had too many hearings on this. If there's no
I'm not
spinning
spinning
to be
it, I'm
done.
saying it's been spun.
You are, because the court had that paper of June 25th, 2015. It was discussed in court, and it was found in court not to be compliant. So thank you for your advocacy, but we can't spin it now. It's too late. We've already discussed that.
And I think this has gotten out of control. I mean,
Mostly
now it has-
because of your client, Mr. Weatherford.
I don't see anywhere in here that it had to be through Sylvan. That was definitely a letter from counsel to her
That
counsel.
was his choosing.
Right. And again, I'm reading the court documents, and any court order is going to say "or," and she complied with that. I mean, I'm a licensed attorney. I've been doing this for 15 years.
I'm the judge.
I
I've been
would-
presiding
right.
over this case for almost 2 years.
And I would say CCSD would be appropriate reading these
Except she was
documents.
in court, and I told her it didn't comply.
So then it kept
Except
changing.
she's had months, almost a year, to comply. I told her a year ago it didn't comply. She's been put on notice it didn't comply, and he's tasked with paying for it. So we can't spin it now. It's been a year.
And on the exhibits that she filed yesterday, there's more math testing through CCSD.
Put your client on the stand and show cause. Your case.
Right, we're going to have to take the stand here.
Can you please raise your right hand? You do solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated.
Can you say and spell your last name for the record, please?
Wealthy Silva, W-E-L-T-H-Y, Silva, S-I-L-V-A.
And just some preliminary matters. I'm going to try to speed through this real quick. You're the plaintiff in this matter,
Yes, I am.
and you were married to Rogerio Silva, and you have one minor child.
Yes.
And you were ordered at one point to have her tested mathematically.
Yes.
And what was your understanding of that order?
Actually, the original order was to have her tested in math and reading. And, like it says, his choice, he was to choose the place and pay for it, and I was to take her. Well, he sent me a message through Family Wizard for a lady, I can't remember her name, but the court has these papers as well, for a reading specialist, a Clark County Public School reading specialist. He never said anything about math in this Family Wizard. Okay, the original thing, I understand the court was saying math and reading, but he sent me, and it was his choosing, he sent me a message about a reading specialist. So I took Annie to that reading specialist, and she tested her. And she said, the child is great. Her vocabulary is like more than grade level.
Hearsay.
And, well, there is a letter. There is a letter from
Do we have an exhibit? Do you wish to introduce an
the
exhibit?
lady.
I don't know where the exhibit is, unfortunately.
Sustained.
Do you know if, and please, when you're testifying,
Sure.
please testify to your own personal knowledge and not what anybody else said?
Sure.
Okay.
Okay.
As a result of this test, were you given any results?
Yes, that she was at grade level.
And did you provide these results to your attorney?
Yes, I did.
And do you know, sitting here today, were they provided to opposing counsel or the court?
I believe they were, yes.
Can you direct me to where I could find that? About what month or
I
year it would be?
I
On
have a-
relevance, we're not here about the reading testing, we're here about the math testing.
And again, she said that she asked Dad who she would like it being tested through. Dad did not respond for math, only for reading, and she complied with those orders.
And Your Honor, you've already noted the letter that's been made evidence in this case already about the letter between counsel about Sylvan. This isn't anything
Stick to the
new.
math.
Okay. So did you ever have Annie tested for math?
Yes, I did.
And what types of tests did you do or have done?
I did one myself through an online. I looked up standardized testing for 5th grade math, and I printed that out and had Annie do it. I also took her to Lauren Beatty, who is a public school teacher at Hyde Park Middle School, I think it is, and she tested her as well.
And you've been homeschooling Annie for how long?
Oh, I believe 3 years while he was in the house. 3 years before the divorce, I was homeschooling her. And then, I guess, 3 years after that.
When you had Annie tested at the Hyde Park Middle School, Prior to that time, did you receive any notification from Dad about where he wanted Annie tested?
He sent a few different things, but they were very confusing because he would tell me about Kuman, and then he would give me a phone number for Sylvan, or he would give me the Sylvan, or another message would be about Sylvan, but it would be a wrong phone number, or somebody's name that I would call the place and they didn't even work there.
After you had Annie tested at CCDC, did you have occasion to have her tested anywhere else?
No.
And why is that?
Because his messages were so confusing, and I felt I've already done everything that I was supposed to do here, and I'm certainly keeping, I felt that I was doing what I needed to do for Annie to keep her as happy and comfortable with math.
And
as I
what
could.
kind of homeschool grades was Annie getting,
100%.
including math?
Yes, including math.
And sitting there as a mother, are you confident in Annie's math skills at the grade level she's at?
I am.
Thank you. No further questions. Oh, one more. I'm sorry. Did you intentionally and/or willfully violate this court's order for her testing?
Absolutely not. Every day I wake up and think, what is best for Annie? How can I keep her father happy? How can I keep the court happy while keeping Annie safe and happy? That's what I do.
Thank you.
Can I leave?
No. Ms. Cohen?
Thank you, Your Honor.
May I have a drink of water?
Yes. Frank, can you give her a drink,
You can
please?
see her now.
Okay.
How do you know Lauren Beatty?
She's a friend of mine. Well, was. We haven't spoken in a while, but
Okay. Do you know if she holds any credentials?
she is a Clark County public school teacher.
Do you know if she holds any credentials beyond that?
No?
Do you know if she has any certifications to give standardized testing?
Well, I would think that she does. If she's
Do you know?
if she's a Clark County public school teacher, I would assume that she does, yes.
Do you know whether she does or doesn't?
Do all Clark County school teachers not have that ability?
I'm asking if you know whether she does or does not.
Just answer the question.
No.
You testified that Ruggiero sent you confusing information about where he wanted testing done. Is that correct?
That is correct.
Do you have any letters that your counsel sent his attorney saying that there was confusion and you needed clarification?
No?
Do you know if any letters were sent?
Do not know.
Did you send him any messages on Our Family Wizard saying that you were confused?
Yes?
Okay. Have you made those evidence to the court?
No. Actually, I'm not sure. Maybe I did at some point.
How many questions was in Lauren Beatty's testing?
I believe it was 5.
Do you believe that 5 questions is valid testing to determine if a child is of sufficient grade level?
Yes, I do. They covered all the 5th grade math stuff.
So it's your testimony here today that 5th grade math can be tested in 5 questions.
Yes, ma'am.
How many math questions does it take to determine 7th grade math?
I don't know. This was not a 7th grade math test.
That's correct, but do you plan to homeschool Annie for 7th grade?
No, actually, I'm perfectly happy with the school that he signed her up at. I'm really happy with that school.
Duly noted. Did Ruggiero ever tell you that Lauren Beatty was acceptable to him for testing?
No.
And in fact, he filed several pleadings with the court regarding math testing. Correct?
I suppose he did, yes. He's filed a lot of stuff.
Did that give you an indication that that was not acceptable testing for him?
I'm going to be very honest. I don't feel that I can ever please him, no matter what I do.
All right. And in fact, you attached to plaintiff's objection to defendant's order to show cause grade contempt a Our Family Wizard report with messages between you and Ruggiero regarding Annie's testing,
Yes.
where in fact Ruggiero tells you that he was not happy with the testing that Annie received. Isn't that correct?
That is correct.
Can you point to that particular?
I'm sorry,
exhibit?
it's plaintiff's exhibit 3.
Attached to her objection filed yesterday?
Yes.
Thank you.
So in fact, you were aware that Ruggiero did not believe the testing that you did was acceptable.
Well, I felt it was a shame because his daughter was still happy and loving math and loving learning, and I was begging him to please be happy with that test because I felt it was sufficient and he could clearly see if she can do math or not. It should have satisfied anyone.
But is that a yes or no?
He's never going to be satisfied.
Is that a yes or no?
Ask the question again, please.
Did you understand that Ruggiero was not satisfied with this
Yes,
math
I
test?
understood that.
Okay, and did you file any motions with the court asking the court to change its order that Annie be tested through Clark County School District or another facility of Ruggiero's choice?
No, because I don't have funds to just make motions all the time. I choose to spend my money taking care of Annie instead.
Okay, and so you simply chose not to comply with the order?
No, I tried my very best to keep all involved happy.
Okay, but you...
Some middle ground to keep the court happy, him happy, and do what's right for Annie.
But you didn't send a letter to Ruggiero's counsel saying that you were confused by what he wanted, correct?
Well, I had counsel at the time, so I suppose they should have done that, right?
Did they send a letter?
I do not know.
Okay. Or did you direct them to send a letter?
I believe there was a letter. Let me see. There was a letter sent to his counsel. There was. I can't tell you the date right now, but there was a letter to some effect of something to do with the testing.
Okay. And what was the result of that?
Again, I do not remember. It's been so long ago.
All right. But you don't have that now, that letter now?
I'm sure I have it at home somewhere.
Okay. But today was the day for the hearing for the order to show
Okay,
cause
no, I do
against
not
you.
have it right now.
Okay. And you've never provided that letter to the court to say, here's evidence I tried to get this worked out, correct?
I think my evidence that I've tried to get it worked out is the math test and the Family Wizard communication with him.
But the math test isn't what the court ordered, correct?
I've done my best here.
Is the math test what the court ordered?
Objection calls for legal conclusion.
Your Honor,
Thank you.
the order,
Sustained. I don't need any further testimony. I think we've covered it. Regarding the math testing, I mean, that's what we're here for today, because the May 12th order wasn't finalized, and HELOC is the subject of trial. She's put on her testimony that she didn't comply with the order. Whether or not she thinks she did is really irrelevant. You can step down, Ms. Silva. When we were here in November, I made it clear that plaintiff had not complied with the court's order. But whether or not she chose to believe that, it's unfortunate.
Your Honor, if you can direct me to the date of the order that says this, because I know your argument that the minutes aren't an official copy of the hearing. However, there was an order prepared pursuant to those minutes. It was filed on May 4th, 2015, and again it quotes the same language. The minor child shall be tested by the CCSD or... And so I have not seen an actual
December
order.
23rd, 2015.
also, if I may, Your Honor, July 21st, 2015. Testing to be completed within the next 30 days.
Yes, there were at least 3 orders. The last one, where the order to show cause was issued, says it's hereby ordered that order to show cause shall be issued regarding plaintiff's failure to complete the math testing as represented in counsel's letter dated July 27th and the order. The July 27th, 2015 letter said he wants her tested at Sylvan. And then when there was an August 5th, 2015 letter after that, this is all attached to the motion for order to show cause. Why haven't you responded, Mr. Tillman? We asked that she be tested at Sylvan. So she's been on notice since then that she still hasn't complied with the order as of November 4th, 2015. The original order said as of February 18th, minor child is to be tested by CCSD or another facility of father's choosing. So it was up to Dad whether or not it was CCSD or another facility. He chose that facility after we were here in court on the June 25th, 2015 piece of paper with 5 math questions on it. He objected to that, said he didn't think it was a valid test. He wanted a full test on math, and I agreed with him, and I gave him the order that it should be done within 30 days. And she didn't do it in 30 days. We were back here in November, and I issued an order to show cause, and she still didn't do it.
All right, Judge, I know I'm going to be a stickler for details, but the the July 21st order from May 26th just says the testing should be done within 30 days. Is there one that says that it had to be done at Dad's choosing?
Previous order.
And again, the previous order says the minor child shall be tested through CCSD. That's
Counsel,
one order.
for you to argue the language when you weren't in court and you haven't been in court for all the subsequent hearings is absolutely ridiculous.
I'm
For you
going
to
by-
spin the language now, because we all know what it meant, and we discussed it in court. There's been many, many discussions in court. There was never a misunderstanding as to who would be doing the testing, someone of father's choosing. So don't continue that argument.
I'm just saying under
Or I will hold you in
CCFS.
contempt. Do you understand me? That is a frivolous argument. We all know that. You're coming in today and making a frivolous argument because we've been here so many times on that issue. And she's been on notice since November. It did not meet the standards, did not meet the court order, and she's done nothing to fix that problem. So she is in violation. So stop the frivolous arguments. You're testing my patience. I agree with her on her other objections. Okay, the May 12th order was not finalized. Cannot be an order to show cause on that. The HELOC was subject of an evidentiary hearing that got vacated because I ordered them both to go to psychological testing and for a full custody evaluation that she couldn't pay for, so that didn't happen. It's still subject of an evidentiary hearing, and we're going to be back here October the 11th. I hope you will be here.
And then my last argument is an unclean hands argument. And he comes in here not paying his child support. He hasn't done the... Way back when this case was first initiated, you ordered him,
Is
and on
there a
several
counter
occasions...
motion?
There is not, but an unclean hands argument doesn't have to be brought up in a counter motion. This is in order to show cause. This is an argument why she should not be held in contempt.
For the record,
He was to pay for the testing. It didn't cost her a dime.
No, not for the testing. He was ordered to do the parenting classes, which
But do
he
you
never
see the
did.
problem I'm having with the unclean hands argument? When it didn't cost her a dime, all she had to do was deliver the child to a facility? That was it. That simple.
Then I would ask, was there any proof that he prepaid for it? Because payment has to be given either at or
I
before.
appreciate your arguments. Please have a seat. Plaintiff is in contempt of the court's orders that the child be math tested at a facility of father's choosing. I'm sanctioning her the amount of $500 plus attorney's fees and costs for having to bring the motion in to conduct the hearing for today. The other matters are disposed of as I have previously ruled. October the 11th, 2016, will be here on the HELOC issue and a change in custody as requested by the father, as well as child support. Now, you need to file a memorandum of fees and costs within 10 days. Ms. Silva, whether or not you have counsel, you have 10 days to object to the memorandum of fees and costs.
And for
Any
the
questions?
record, counsel could serve me with the memorandum of fees and costs, and I'll make sure it gets to...
Very good. Thank you, Mr. Weatherford.
You discussed visitation. I have no contact right now with my child. I haven't seen her in a month and a half.
There's no motion pending.
There's no motion pending.
Your Honor, for my clarification, will we be addressing the contempt for the failure to have visitation per the decree, per all of the orders, from April of 2015 until June of this year? Will that be addressed in October at the hearing? Because I thought that was part of what our hearing today wasn't just for that one order. I thought it was for all of those orders and the failure to have that visitation and all of those subsequent visitations along the way.
Counsel, the way the court is looking at all of these events is, in their totality, what do they mean as far as custody? And yes, if you want to submit an affidavit and go through the rigmarole of an order to show cause, and I do call it that because you have to comply with AWOD and have an affidavit, and the court orders being signed, we have an evidentiary hearing coming up. All of that is going to be relevant to the evidentiary hearing and the final orders of the court. So I'm not telling you you can't do it, but you'll still need to renew your motion for order to show cause with an affidavit supporting all of this. Because the order to show cause I issued cannot go forward on that May 12th order. Hasn't been finalized.
And then, Your Honor, the $500 sanctions, is that reduced?
The judgment, yes.
And, okay, so, and are there any findings, just the finding of contempt? Is there any other findings with?
I still want her math tested by someone of father's choosing.
She's already going to school.
At the school, are they going to be doing that?
I'm not clear on that. I can ask.
Okay, I know with the school, it's, and for the
They
record.
probably have to test her before they put her in her grade. No?
But it's
They
a,
didn't require it, but I can look more.
It's up to
into
you,
it.
sir. You made the request.
At this
But it
point,
seems a little ridiculous to hold mom in contempt if you're not going to have her tested.
we can have her
well,
tested.
because now she's in a school where she's actually going to get the proper education.
Not yet.
As opposed to.
She's not in school
But
yet.
she's registered.
Okay?
So it's a Clark County School District school that's Montessori, which is what they both wanted. So it's a Clark County School District Montessori school, so she'll be getting the proper training. That's the issue. That was the concern. She wasn't getting the proper education.
And his
before.
other concern
Now
was
we
that
know.
she is at her grade level.
She got dropped down to a grade.
Yeah, now they're starting her a little lower because.
What grade
they're
is
not
she going to
sure.
be in?
She's supposed to be in 7th grade. She's
Okay.
going for a
That's
6.
authorization.
Excuse me.
She's going into 6th grade?
Yes, ma'am.
That's what the school wants to do.
How did they determine that she was going to be in 6th
She
grade?
doesn't have the credits enough by the time she reaches high school level. So she needs to build up credits.
Have you had a
Separate.
parent-teacher conference?
Not yet.
Okay, because Mom needs to be aware of this.
And she's been to the school. She,
Multiple times.
yeah, Dad let her know this wasn't something. Even though you gave him temporary sole legal and sole physical, he's given her this information. He's not doing this on his own.
And Judge, we'd ask that she be tested because these tests might provide that she should go into 7th
No,
grade instead of
don't.
6th. You don't wanna do-
Mom can
bother her. I don't wanna burden
participate
her.
with the school. I expect
Don't
her to
wanna
be
burden her.
involved with the school.
year of school.
Yeah, although we would like to, Mom, so Dad asked Mom for her shot records, and she said, oh, it's okay, I'll take them to the school, and then went to the school and filled out a form saying that she had religious objections to their daughter getting vaccinated. So and we just want to make sure tricks like that don't happen. Oh, it's okay, I'll take care of this, and then I'm going to sneak in and not co-parent and be up to my old tricks. So he is perfectly happy having her involved, having her participate, but this is part of the problem. She still isn't co-parenting, she's trying to take advantage, and like I said, when he said, hey, what are the shot records so I can give them to the school, the response is, I'll take them to the school, and then I'm going to fill out a form that says I have authority to say that my religious objections are keeping our daughter from being vaccinated, when you had already ordered in front of her that he had temporary, sole legal, and physical.
It was not in front of me.
Oh, sorry, it wasn't in front of her, but yeah, she's right, it wasn't in front of her, but the order had already been issued and been provided to her.
And Dad could provide the order to the school, and then that would fix this issue.
And the school caught it, and that's why we knew about it, because the school had the order, and the school contacted him and made sure that that wasn't
They have her shot
didn't
records. I
happen.
gave them their shot
Is she-
But
records.
that was
Another
him
shot?
reaching
Yes,
out,
they've got the
co-parenting,
shot
despite your
records.
order, still being a co-parenter, and her taking advantage.
It's certainly going to be an issue in October.
Right, but just so I want to be clear with when your order that she be involved with the schooling, I want to make sure that it's clear that she understands that that doesn't mean she does things on the sly now and thinks, well, the judge said I could be involved. That's not what being involved means.
I understand
That's-
your point.
And I
She is
hope
to be
she
she
understands.
is to be informed of the school schedule, what class Annie is placed in, whether or not Annie has an IEP, for example. If she needs to meet with the teachers, she can certainly do that, but she's not to direct her education because you do have sole legal custody temporarily. So you are to make the decisions. It's not that she won't have the information. So I want that to be clear in the order, Ms. Cohen.
Okay, definitely, Your Honor. So, all right. Okay, and so the finding contempt because of not.
Mr. Marshall, would you like this back?
Okay, and so I'm sorry, Your Honor, just to be clear, do you want, my clients will do the testing outside of the school, but do you want that to be a part of the order, or?
He's still able to do the testing.
Okay. All right.
Mr. Weatherford, you said you would sign off?
Yes.
Okay. Thank you. I appreciate the difficulty you had today in coming in and pinch hitting. I hope that you will be here in October.
Thank you, Judge.
Thank you.
Always good to see you.